adjournments?
We've been here on a few different adjournments. I think this was the date and time set for the last settlement conference. Defendants requested a jury trial. There was an escrow order that was put in place January 5th. That escrow order, though the sums have been paid properly, the timing of the order was breached. It's required to pay rent within the same time period as the lease, either the 1st or late by the 5th. We have escrow payments that were made February 15th, February 16th, that would have been late for the month of February, which would result in the waiver of the jury. So as a result, if the court is still inclined to proceed forward with the trial, it should just be a bench trial at this point. It should be set relatively quickly. I believe the escrow order would have required it to be set within 14 days. We have filed an answer. The court had adjourned previously when the defendant filed an answer to this, that their affirmative defenses could have been read as counterclaims. So we did file an answer to the end to avoidance of the affirmative defenses with the court. Ready to proceed now, though I still don't think there's a tribal issue of fact. I know the court has allowed it to go this far and is granting her the jury trial.
Do you have a response?
Yes, Your Honor, I believe that there are tribal issues. I can prove with evidence retaliatory eviction, illegal lockout, changing locks. I communicated the need for repairs, gave plenty of time. They were not done. This ultimately stems from a personal dispute by Ms. Serena's husband. I have been trying to get help from state emergency relief. I had to wait a little while for my appointment, and I had it last week. And thank God I was approved for some support up to $3,000, but the landlord refused to accept it. There has been no serious health hazard done, and they will not be able to prove that such a thing occurred. I will be able to share context.
Well, let me ask this. And it's a rather odd termination because one of the things is a failure to pay rent that was on there. But that aside, have the health hazards that were alleged, have they been corrected?
No, I've been living in this winter with a broken window. I have been living without a thermostat because the landlord took it away. It's one of those Wi-Fi thermostats. Mitch.
What do you mean they took it away?
So it's a three level unit, Your Honor. The thermostat is in one of the other units, which is set to 72 degrees and stays there. She's never had access to the thermostat.
That's not true. When I moved in for 5 months, I did have a thermostat that I used, and I keep different hours. I'm disabled. I tend to be more awake at night when their schedule fits probably more of a 9 to 5. So what's happening is at night, the house is freezing cold when I'm trying to accomplish things. I've had issues with the lighting in several areas where.
Hold on.
Yes,
Hold
sir.
on. In the rental balance, so maybe we can get that part. What is the balance that you're claiming is owed?
The balance of rent, not including the escrow, Your Honor, would have been $5,390 through this month. I do believe escrow was paid this month, sometime around March 1st for $980. Otherwise,
well, I don't have $980 in rent. Unless some came out. I have $870, which was paid on the.
Oh, yes, sir, because last month I paid a little extra ahead. So when I was here to make my payment, I asked the clerk to tell me the amount that was paid extra. So if the total balance should reflect the 3 months.
It may. I'm just saying counsel had indicated a certain amount had been paid, and I'm indicating there was $870 paid.
The whole amount was paid in pieces. Yes, sir.
From the onset of this case, Your Honor, it's $6,370 in total rent paid.
Say again.
$6,370 would be the rent due and owing.
6,300. Give me that. $70.
Just so the court is aware too, the lease expires April 30th.
What do you have as the amount of rent?
I have 2,939.98.
All right. So the lease expires April 30th.
Correct, Your Honor.
Are you intending on moving or what is the,
Yes,
okay.
I wanted to stay at my apartment.
Pardon?
I wanted to live in my apartment for the full lease term. I'm planning to move out at the end of April.
Okay. All right.
One of the, so I would like to see proper accounting of the claim of that amount, because the last time it was requested, it was not done properly. And
What do you mean the last time? I'm not sure what you're referring to.
At the December 22nd hearing, Your Honor, defendant requested an accounting of the rents that were paid. We did a notice of filing showing both her payments as well as the payments of her prior co-tenant, because
that
it
is
was
not true. That is not true. I have not received that. That's what I asked
Hold
for.
on.
Yes,
Okay.
sir. I'm trying very hard.
Okay. And you're saying you didn't receive it.
I did not receive anything that reflected what my roommate contributed. I did not see that, what Attorney Backman just said.
And
It's
Your
not
Honor, that
true.
was addressed at the last hearing where she indicated that
Thought it was.
a proper accounting. She didn't like the way the accounting was drafted, but it was in and of itself an accounting of all of the rents paid by both sides showing.
And maybe we review it together.
We who?
He's saying it is, I'm saying it ain't. Let's,
Okay. Here, I think that's what let me put it this way. What I'm looking is what issues at trial I'm going to have to deal with. Obviously, I'm going to have to deal with that. So,
I have an additional copy, Your Honor, for the defendant, so I'll make sure.
Okay.
yeah, and I heard you said is this the answer? Because I didn't receive any additional information. You said you filed with the court.
Your Honor, I have an additional copy of the answer to the affirmative defense.
I mean, how do I get that?
These were all mailed, Your Honor.
Well, they haven't been received yet.
okay, now they have. All right. So what the court's going to find regarding trial, because obviously we're not going to be able to resolve it here at a final summit conference, is that given the way that escrow was paid, the problem is that escrow needed to be paid within the time frame specified, and it wasn't. It was paid, all right, but you have to. No, I'm not faulting you for that. I'm just saying.
Which month was it? Because this month I came in as soon as I got my social security deposit. I only get the one amount per month. And
No, I get it. I mean, it's not, but what I'm saying is there's timeframes for it to be paid. What I did is I think that the jury has been waived.
Correct, Your Honor.
And so that's it. That doesn't mean that you don't get a trial. I delayed it in terms of what would normally happen is I would have said, jury's waived, they get an immediate trial. The problem is you had not yet gotten all of your things together to get to the court. And so I was allowing that to happen. That doesn't really affect the waiver. It more affects the timing of the trial and then the payments. So there will be a trial on possession. I will set a trial on possession. Here is my real fundamental question for the parties, because I can get you in. It's time in April. And realistically, just thinking, lease expires April 30th, right? There'd be a trial. We could certainly spend our time on a trial or agree to a move out at the end of April, because I mean, you're going to somehow or another, you're going to have to figure out the figures of what may be owed, right?
I can do
But, and I know you can do that. You're going to come to a different number than that. I know how I've been with you guys
Yeah,
long enough.
follow.
I know what's gonna happen. So, but what I'm saying, I guess my bottom line to it is I'll give a trial date. Right? That's not a problem. But the reality is you're going to be moving out at the end of April, right? And that's what they're looking to have happen. I don't know why we can't just figure everything out with a move out date of April.
And I'm okay with that. I would be willing to negotiate with them, but after I got the approval, they said, yeah, we're gonna help you with the 3,000 from SOS. The total amount that I had was just under 3,000. So here I am happy. I'm gonna get some support.
Hold on a second. So did they say they were going to do that?
Yes, I have the email that I can share with the court. Miss Alicia, last name.
So Alicia, that's fine.
Yeah,
from SOS.
Yeah, and I have a letter that states the landlord declined to participate in the program. So they're suing me for money. I was able to get money, but they don't want to come. I was, Alicia basically said, which is my, I have an email. It says that, I've been waiting all this time for the extra help. So, they're kind of just throwing everything on the wall to see what sticks. They're claiming rent, but the rent was withheld because of a failure to secure a property that's habitable. The landlord busted off the locks. I lived without locks in my apartment for several months. I had people break.
Okay, I'm not here to try this right now. Okay. If you say that there's assistance, they declined to participate in the program, then I can't do anything about that. I can't force them to do that.
Yeah, it's just odd, right?
Pardon?
It's odd.
It's not necessarily odd. I mean, some landlords participate, some don't.
I'll speak with my clients as a person.
I was wondering if they should contact Zorica instead of Mitch, because Mitch is the rude.
All that aside, Your Honor, I don't know if the court would prefer, given that there's an indication from the defendant that should be moving out at the end of the month, to set the trial in May, just not to waste the court's time. I hate to kick this out any further. My fear is that we'll have the issue over not just possession, but damages and rent. That'll be the bigger.
Because there wasn't a permanent ongoing problem.
So possession is already handled. Setting it in May save the court time.
You have any problem with me setting a May trial date then instead of an April one?
Preferred the jury trial that I requested.
I know, and I'm deeming that it's been waived.
Okay.
So
I'm willing to be at trial whenever is convenient for the court.
Okay, but what counsel's suggesting is a May trial date because you said you're going to move in April. And so it may be that the trial may not be necessary. It can be resolved that way.
Because it's a retaliatory eviction and I want my damages.
I get that. Yeah. But the certain issues regarding possession and other things would be done with if I set it in May. As opposed to if I set it, it's going to be early April. And here's what I don't want to run into potentially is a situation where, let's say, and I'm not saying how I'm going to rule, but I'm just saying, let's say I rule in their favor. And then there's an order of eviction for, let's say, April 15th. And then, but you're going to be out the 30th anyway.
I'd be willing to be out tomorrow if they would just accept the $3,000 and say I don't owe them any money and we move on. It's only a month left.
Okay.
Otherwise,
then that may be an option you guys can work out. And let me just say this: I don't know this for sure. Part of the reason why they may not have accepted the 3,000 is because the funding technically is to preserve housing. So the question of you moving out at a particular point in time may affect that 3,000 and whether or not they pay it.
Okay.
Yeah. Well, it's a hypothetical, but it depends on what program it's coming from, is what I'm saying. So it may be that it's not entirely as simple as that. Because what used to happen is somebody would get an email like you did. They'd contact the landlord, and what they want is they want then a lease that continues on. And if the landlord said, no, that's not going to happen, that will look like their rejection. I'm just saying, I don't know that happened in this case, but I could see that potentially being an issue in this case. All right.
Potential, not plausible.
Okay, however you want to phrase it. All right. So here's what I'm going to do. I'm going to indicate the jury trial's been waived. I think the best thing to do, folks.
So what month was it that I missed the window?
Well, actually, the first period in time, you actually would have missed it.
The first period when it was first ordered?
Yes, ma'am.
It was ordered after the payment due date, wasn't it? We're talking about.
Well, there was a escrow was prorated, and then when you came into hold on. When you came into February, you did a partial.
I've already.
And then, if you're going to try to overtalk me, I can't do it that way.
How else may I respond to things that I'm concerned about? I don't have, I will write them down.
All right. That's my ruling on it. I'm also going to then set non-jury trial in this matter. Give me a May date. I need it before then.
Do Tuesday, May 7th, you know?
Thank you. That non-jury trial, May 7th, 2024 at 9 a.m. Right. And that's what we do. And you're going to check into with SOS.
Yeah, sure.
And that.
Do you have their contact info I can share with you?
That's what I was going to suggest. If you can get the contact information so council knows, and then that way, maybe that'll work out that back amount in some way. Okay.
Thank you, Your Honor.
Thank you.
In this landlord-tenant matter, the court convened for what was intended to be a final settlement conference after multiple prior adjournments, during which the defendants had requested a jury trial and an escrow order had been issued on January 5, requiring rent payments to be made in strict compliance with the lease terms. The landlord argued that although escrow payments were ultimately made, they were untimely for February, resulting in a violation of the escrow order and a waiver of the tenant's right to a jury trial, thereby converting the matter to a bench trial. The tenant strongly disagreed, asserting that there were genuine triable issues including retaliatory eviction, illegal lockout, failure to make repairs, lack of heat control, broken windows, and alleged habitability violations, and further claimed that rent had been withheld due to these conditions. The tenant also explained that she had sought and received approval for emergency rental assistance of nearly $3,000 through a state program, but alleged the landlord refused to accept the funds. The court carefully questioned both sides regarding rent payments, escrow accounting, lease expiration, and the claimed habitability issues, clarifying that the lease was set to expire on April 30th and confirming that escrow payments had been made, albeit outside the required timeframes. The judge ultimately ruled that while the tenant still retained the right to a trial, the jury trial had been waived due to the escrow violations, and that the case would proceed as a non-jury trial. The court also acknowledged that, given the impending lease expiration and the tenant's stated intent to move out by the end of April, a trial focused on possession might become unnecessary, though issues related to damages, rent, and alleged retaliation could still remain. To avoid conflicting outcomes and unnecessary proceedings, the court set a non-jury trial date for May 7, 2024, allowing time for potential resolution, further accounting clarification, and possible coordination with rental assistance agencies. The judge emphasized that while the court could not compel the landlord to accept emergency assistance, the parties were encouraged to continue discussions to resolve outstanding financial disputes before trial. For more information, like and subscribe to my channel.
Versus Nicole Cooley.
Is it the prosecuting attorney for Rosa, but she's on Zoom? And there's no one.
She's on Zoom, Miss Cooley.
Good morning, Your Honor. My name is Nicole Murdoch.
Got it. We don't have it that way, but I got it. Okay. All right. She doesn't have counsel. What is this? All right. Ma'am, you don't have counsel representing you?
I was just there, seeing you a few, last week, if I'm not mistaken, and we tried to take care of this old ticket. But I guess they said we couldn't at the time or something.
You were here. My staff indicate you were here, but that was on something different.
Yes, sir. And we discussed this ticket, and I guess they said.
Okay. Ms. Barroso?
I have had no contact with this defendant whatsoever.
All right. Ma'am, did you want to be represented by an attorney to help you get through this thing?
Your Honor, if I recall correctly, the last time I was in your court on this ticket, we were waiting on the officer to say it was me. And I want to say this was back in 1992, if I'm not mistaken.
Seriously?
Yes, sir.
I was like 4 years old.
So I'm not sure if someone used my name.
Well,
Ticket
so-
kind of fell out the sky.
Ma'am, if it's 1990, you said it was 1992?
I mean, if it's old, Your Honor. I don't know the exact date.
I wasn't on the bench in 92, so it wasn't me.
I don't think, maybe we might not have been before you, to be honest.
The ticket's from 2004.
Oh, well, excuse me, sir. I know it's old.
I was on the bench at that time, but I don't think you were ever before me.
Yes,
I don't have nothing in the file indicates or is my writing.
Good.
Oh, good. I didn't meet you either.
Well, not like that, Your Honor. No, all due respect. I was just saying,
Yeah. She's probably gonna say something like 2004. I wasn't even born. Watch.
See what I'm saying? It was old. It fell out the sky, literally.
I know. It's old. We get it. For
Valid
those
now.
of us.
Is her license valid now?
Pardon?
Does she have a valid license now?
Do you have a valid Thank you. Maybe what we should. Do you have a valid license now?
You just gave me the clearance when I paid the $45 when I was there.
Okay, but is your license valid now?
I haven't gotten down to get it, Your Honor. I've been working midnights. I literally just got off work like a few hours ago and took my son to school.
Why don't we adjourn it
So,
for her to get a valid
ma'am,
license?
Yes, sir.
Do you have a drunk driving that is pending?
No.
So at some point, did you have a drunk driving?
Is that what I was just seeing and posted $1,000 bond when I seen you last week? If I don't know, Your Honor, to be honest, I don't want to lie to you.
All right, ma'am. Because your license status indicates that it's suspended on a 625G permit.
What is that?
Okay. That's a piece of paper that you get once you get caught for drunk driving. Allegedly.
Oh, I don't know. I don't have
Yeah,
them.
okay. Let me ask you again. Do you want to be represented by an attorney?
I guess so.
Yeah. Okay. So this is now a public defender case. Good luck. I mean,
Good morning.
Oh my God, Your Honor.
On behalf of Ms. Murdoch or Ms. Cooley, as the case says, we will waive any further reading and stand mute. So that's for adjournment. So
she was already arraigned back in 2016, so I'm just going to adjourn out the pre-trial,
oh, I see. Okay.
and I will continue her bond. So, ma'am, I've appointed, or the PD is now the attorney on your case, okay? They're going to be able to take a look at it, and they're going to be contacting you, all right?
You're scaring me, Your Honor. You said good luck.
Don't let that scare you. It's
Okay.
just trying to sort out something this old, because when I ask you questions, you can't answer them legitimately. You can't answer them because you can't remember. But don't get
Okay.
scared.
We'll get into
Okay.
Okay?
Okay.
Don't
I'm
get
just
scared
making
until I
sure.
tell you to get scared. And if I tell you to get scared, then get scared.
I hear you, sir. Okay.
Spell Murdoch so that we can include it in our file.
How is your last name spelled? Is it Murdock?
Yes, sir, it is.
Thank you.
You're
They just wanted to
welcome.
make sure it's included in the file. So
Okay.
how much time did you want? April 3rd or 17th?
If the third works for the court, we'd ask for that, please.
All right. Ma'am, I'm going to adjourn your matter to April 3rd, 2024, 9 a.m.
Okay, via Zoom as well, Your Honor?
Yes, you could appear via Zoom unless you want to come down and see me, since we haven't
No,
seen each
thank
other in a
you.
while.
We'll keep it via Zoom for now.
All right. Okay, Miss Murdoch.
All right. Have a good day.
Okay, you take care.
Yeah, bye-bye.
Bye.
In this hearing, the court addressed an unusually old traffic-related case involving Ms. Nicole Murdoch, who appeared via Zoom without legal representation and expressed confusion about the nature and age of the charge. The judge noted that Ms. Murdoch had appeared in court the previous week on a different matter and that this particular ticket dated back many years, ultimately clarifying that the citation originated in 2004. Ms. Murdoch stated that she had little memory of the case due to its age and appeared genuinely uncertain about the circumstances surrounding it, prompting light but pointed exchanges with the court as the judge attempted to determine whether she had ever previously appeared before him or understood the underlying offense. As the discussion continued, the court shifted focus to Ms. Murdoch's current driver's license status, discovering that although she had recently paid a fee, her license remained suspended under a permit related to a prior drunk driving matter. Ms. Murdoch was unable to clearly explain the suspension, acknowledging difficulty recalling events tied to the old charge, which raised concerns for the court about her ability to navigate the case without assistance. Given the age of the matter, the uncertainty surrounding the defendant's recollection, and the potential legal consequences connected to her license status, the judge strongly recommended legal representation. After initially hesitating, Ms. Murdoch agreed to be represented, and the court formally appointed the public defender's office to take over her case. The judge reassured her that the appointment was procedural and intended to help resolve the long-standing issue fairly and accurately, emphasizing that her confusion was understandable given the passage of time. The court then adjourned the matter, continued her bond, and scheduled the next hearing for April 3rd, 2024, at 9 a.m., allowing the public defender time to review the file, investigate the history of the case, and advise Ms. Murdoch appropriately. The judge concluded the hearing by ensuring her appearance could continue via Zoom and reminding her not to panic, reinforcing that the goal was to finally bring clarity and resolution to a case that had lingered unresolved for nearly 2 decades. For more information, like and subscribe to my channel.